Felony battery in Indiana. Battery in Indiana can very easily become a felony. And so there's multiple different ways. I'm going to go over some of the most common ones. So just like misdemeanor battery, there has to be a rude, insolent, or angry touch. The previous examples have been a poke in the chest after you found the person who ate your lunch. Why'd you eat my lunch? If that doesn't result in pain, just the touching itself is a misdemeanor battery. If the person says, ouch, that's a misdemeanor battery. But if you poke that person and you break their rib or you cause a fracture on their rib or something like that, but you basically cause moderate bodily injury. So a level 6 felony battery is a rude, insolent, or angry touching that involves moderate bodily injury, which is described as an impairment of physical condition that includes substantial pain. The examples in case law are stitches, a small fracture, a split lip. Those are the type of things we're talking about. So it's more than ouch, it's really ouch, I don't know. The case law is really bad on this. This is a newer statute, came into being in 2016. It used to be bodily injury or serious bodily injury. And then they said, hey, there's not enough ways to punish criminals. Let's start adding moderate bodily injury. So there's not a lot of case law on moderate bodily injury, but the cases that are available do say fracture or small fracture, split lip, stitches. That's going to be enough for moderate bodily injury. Again, it's all up in the air. And so we know that moderate bodily injury is somewhere between bodily injury, ouch, and serious bodily injury, which it's pretty apparent when you have serious bodily injury. Were you unconscious? Do you have an impairment of your bodily member or organ? Did you lose a fetus? So moderate somewhere in between there, and it can really go any direction. So that's the first way that a battery jumps to a level 6 felony, this moderate bodily injury. The second way, or the second most common way I see, is if the battery is against a public safety official. Public safety official is this legal term of art that basically includes police officers, obviously, but it also includes probation officers, parole officers, firefighters, emergency medical technicians, ambulance workers. It also includes the bailiff of a court, but it only includes those individuals when they're actually doing their job. So the most common thing we see is someone's being arrested, but they need to get checked out in the ambulance. And so the ambulance worker is just trying to do their job, take temperature, ask questions, and the person starts moving around too much, and the ambulance worker steps back, and the officer's like, oh, that's a battery, level 6, haha, gotcha. So no pain has to be involved, but a rude, insolent, or angry touch against a public safety official rises that battery to a felony battery. So be super careful. You don't want to fight with emergency medical workers. You don't want to fight with anybody if you're being arrested. But just understand, if you start swinging those elbows, things can get more serious pretty quickly. A level 6 felony is punishable with 2.5 years in jail and a maximum fine of $10,000. Again, felonies are always terrible. And then battery also has the ability to jump to a level 5 felony. Now, a level 5 felony battery, it gets kind of technical. There has to be a rude, insolent, or angry touching that results in serious bodily injury. Serious bodily injury is defined by statute as bodily injury that creates a substantial risk of death or causes serious permanent disfigurement, unconsciousness, extreme pain, permanent or protracted loss of impairment of the function of a bodily member or organ, or loss of a fetus. I don't know what extreme pain is, but we do know that it's greater than moderate or substantial pain. It seems kind of subjective, doesn't it? Some examples of this would include being shot. Being shot, that's going to be serious bodily injury every time. Another example is someone having to have surgery to correct a fracture on their nose along with an impairment of vision for a short period of time. Another example in the case law is somebody getting into a fight and stomping on somebody's already broken leg. That's going to be enough for serious bodily injury. And then unconsciousness, even for briefest of moments, is always going to be enough for serious bodily injury. Now, you don't see too many level 5 batteries, and the ones you do see, you have to be careful, because a level 5 battery, if it's causing this possible disfigurement, extreme pain, substantial chance of death, it can very easily become an aggravated battery, which is a level 3 felony. I'm going to tell you right now, level 3 felony is way worse than level 5. So just make sure you have an attorney that understands nuances of this. If you are charged level 5, you don't want to make that all of a sudden become a level 3, because level 3 is terrible, absolutely terrible. So those are the most common ways. You also see occasionally somebody that commits a battery, a rude, insolent, or angry touching with a deadly weapon. No pain involved. So the example from before, hey, you ate my lunch, and you poke them in the chest with your finger, be misdemeanor battery. If you poke that person with a gun, hey, you ate my lunch, or a baseball bat, hey, how come you ate my lunch? That can become a level 5 felony battery pretty quickly. So leave the weapons out of it if you're confronting someone about stealing your lunch. And be careful that your attorney doesn't mess around and turn your level 5 into level 3. There's tons of ways to defend against batteries. If you have any questions, give us a call, 317-632-3642. And remember, always plead the fifth.